I am Ed Alexander, attorney and founder with Alexander Abramson, a business law firm. Unfortunately, sometimes people come into the office having a partnership problem, and we find that they've downloaded a form for their operating agreement or their shareholders agreement. Now, these forms are readily available. In fact, some of them are free, but certainly not a lot of dollars to get these forms. The problem with them is that they can lead to some significant disasters. And you know, when you're a startup, you're looking to save money. We get that. The problem is that if you become successful, the problems that are baked in sometimes are difficult to change later on as the party's position changes. So some of these would be failing to have a proper valuation mechanism in the case of a buyout. So as we talked about a little bit before, there's a buyout mechanism so that one owner would buy out another owner in the event of a death. And so having the proper valuation mechanism to make sure that the deceased owner's family gets adequately compensated for the value of the business is crucial. The other might be failure to deal with an owner leaving while they're still alive, right? Because maybe the owner wants to move on and do something different. Well, if we don't have a mechanism for making sure that the two can come to agreement on that price, what typically happens is the owner who's leaving thinks that it's worth billions, and the owner who's staying thinks that it's about to go into default, right? So there's a mismatch on what they think the valuation of those are. Another one would be the failure to assign all of the intellectual property that's being used by the business to the business. So if one owner comes to the business with a logo or a profit or a patent or some trade secrets, then we want to make sure that that's transferred over to the business so that the owner, the partner who owns that intellectual property, can't hold the business hostage later on for it.